Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. We have a very interesting case tonight. Interesting and not a little bit crazy, a lot bit crazy. A case that's been going on for 4 years, yet has yet to hit the trial, hasn't reached the trial. In fact, the defendant in this case, Sarah Boone, has gone through 8 attorneys. So many attorneys has she gone through that now the judge has given her permission to represent herself because no attorney can handle dealing with her. So that says a great deal about this case. And it's being referred to as the Suitcase murderer. And we're going to explain the whole thing, but Sarah Boone, the Florida woman accused of zipping her boyfriend inside a suitcase in an alleged game of hide and seek, and then leaving him outside until he died, will soon go on trial on second-degree murder charges more than a year after she was originally scheduled to stand trial. Boone was arrested on February 25th, 2020 by Orange County deputies after detectives said they found Jorge Torres Jr., he was 42 at the time. He had remained in the suitcase for hours outside the couple's Winter Park home. The trial was set for May 13th. Boone called 911 after she said she found Torres inside the suitcase the morning after she said that she and her boyfriend had been drinking and agreed it would be funny to play hide and seek. When the investigators arrived, Torres was dead. Boone was charged with second-degree murder in 2023. So we're going to look at this case. We're going to take a deeper dive into it and see what the heck is this all about, this case. How could this be? How could someone lock a husband? Well, anyway, how did she get him in the suitcase? That's one of the things we want to know, As part of the game, did he voluntarily get into the suitcase and then did she zip it up and refuse to let him out? I mean, that's a bizarre game. Even if you're drinking, I don't get in a suitcase for anybody, It's like someone asking you to get in the trunk of a car. No, that's never a good idea. Nor is it ever a good idea to get into a suitcase. So guys, hold on to your hats. Hold on to your loved ones. Hold on to your service dog, your service cat, whatever pet you got to get you through the day or the night. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone. There has to be some common sense.
Yes, sir. They have the car stopped in 10th and Ranch by Collider.
We still don't know who pulled the trigger.
To present this case this evening, that it's so challenging and so bizarre, I had to have 2 professors join me tonight with their combined brain output. We should be able to address this case in the manner and the way it deserves. And first, joining us, Professor Michael Geary, a retired NYPD Sergeant, a professor at Albertus Magnus College in Connecticut, attorney, all-around good guy, Professor Mike Geary. Welcome to the show, Mike.
Hey, William. Good evening. Welcome, everyone. Thank you for showing up and watching.
And Mike, not to show you up, to bring in another professor who happens to be a doctor, a PhD, Dr. Debbie Goodman from, St. Thomas University in Miami, Florida, a nice place to be right now, Miami, Florida, because only the West Coast seems to get hit with those horrible storms. Welcome to the show, Dr. Debbie.
Good evening, Sergeant Bill, Professor Mike, the viewers. Always an honor to join you. And what a crazy case we have to discuss this evening.
You know, Mike, I know that you have done some research on this case. You read about it. I mean, when you talk about, say, murder second degree, usually you have intent death, cause death, recklessly cause someone's death. This is going to the other area of a depraved indifference to human life, a depraved mind murder. Could you explain that, Mike, since you do have a law degree, right?
Okay. Yeah, usually you mean talking about murder, you're talking about someone is acting with the intent to commit a crime, and here the crime would be murder, the intent to commit murder. And so the result is that the death occurs. But if you're talking about depraved indifference, that's where it's more of a torturous kind of thing, where you prolong the agony, and in some instances, a prolonged agonizing death caused by an actor could actually be grounds for capital punishment, depending on what the actual facts of the case are. But this is a very serious case. It's not a mere accident. Manslaughter might be kind of like an accidental kind of thing, but she's being charged with intentionally causing his death, knowingly causing his death, intentionally causing his death, where the ultimate desire, her end goal, is actually to cause his death, not an accident. It was actually to cause his death. That's how the state sees it based on all the facts of the case so far.
Dr. Debbie, we hear that and we'll play some of it later on, but the attorneys, the prosecution refers to this, the mens rea and the actus rea. You want to explain to our audience the difference between mens rea and actus rea?
Certainly, two components that we take a look at when we're talking about murder, and mens rea really deals with the criminal state of mind. So very similar to what Professor Mike is alluding to. Did the person have the intention to do wrong? Was he or she with understanding about the wrongdoing? And we also refer to that as scienter, knowledge, understanding of wrongdoing. And then the actus reus, of course, literally is the action itself. So the manner in which one takes the steps toward death. And I think on this case, we have both the mens rea, criminal state of mind, as well as the actus reus, the action taken that directly leads to the death of Mr. Torres.
And then, Mike, we have something called the four culpable mental states of mind, which are necessary in fulfilling the requirements for a crime. And of course, they are the acronym RIC, which I still remember myself.
Okay.
Recklessly, intentionally, criminally, negligently, and knowingly. And I would give that acronym to my students so they would remember that. You want to explain that, Mike?
Yeah. If you go from, like, say, murder all the way down to criminal negligent homicide, starts out murder is when you do something intentionally. Okay. You intend, everything that you do, all of your actions are designed to bring about a particular end. In this case, she's being charged with taking actions and desiring the ultimate outcome of the death. Then you have like a reckless kind of action where, you know that what you're doing is dangerous. You might not want to hurt somebody in the end, but what you're doing is inherently dangerous. And in this case, it would be zipping somebody up into a suitcase and like leaving them there for some prolonged period of time. Your ultimate desire is not to kill or not to hurt, but you're getting pleasure out of that person, out of that, the thrill you're getting out of it, or maybe the scariness that you're causing that person. And then you have that lower level, which is a negligent kind of thing, where you really do not have any awareness that what you're doing could actually hurt somebody, and they ultimately get hurt. So there's a number of different levels of criminality when it comes to homicide. And so she's being charged with the highest level of homicide, which is murder with where you're taking actions and you are actually desiring the ultimate outcome and you achieve that outcome.
Well, Mike, this is potentially, and Dr. Debbie, this is potentially a death penalty case because the callousness, and she easily could have saved his life. Just unzip the damn suitcase, and she refused to do so. So therefore, I believe in Florida, she is eligible to meet the Grim Reaper, whoever that guy is with the syringe. She's eligible for that. Dr. Debbie, you have any comments on that?
Yes, I think that a lot of what this case is based on, at least according to her, right? Whether she'll be representing herself, it appears so, having gone through 8-9 attorneys. But I think if we look at what her allegation is, remember initially it was this game of hide and seek and hiding in the suitcase and the zipping up and allegedly, right, the accidental death. But now here we are moving closer to trial. October 7th is the proposed date, and now she has changed the platform from this accident to domestic violence. So if we want to look at domestic violence and just, take our look back, as we often do, at other high profile cases, we could look at O.J. Simpson, Nicole Brown Simpson. Now, we know that LAPD had been called on numerous occasions to the Simpson home. Mrs. Simpson was murdered. Mr. Simpson, of course, was acquitted. However, many in the court of public opinion, let's say, believe that the outcome may have been something other than what the court ruled. We look at the young couple, Gabby Petito, Brian Laundrie. We, meaning society, we all saw police intervention on the body cam when the couple went on a summer vacation, and a passerby was concerned about the interaction, called police. And so we had domestic violence there. Sadly, tragically, Miss Petito was strangled by Brian Laundrie, and he himself, self-inflicted. And we could also look at the Jodi Arias case. Many of the viewers would remember that case, certainly the three of us do, whereby Jodi Arias alleged that she was the victim of domestic violence and that Mr. Travis Alexander, her boyfriend, was the cause of this. However, she stabbed him 30 times upon his exiting of the shower. What was his weapon? Nothing more than a towel. He had no weapon. So now here we are with this case, and the question is domestic violence really something at the forefront? We do know police had been called. Mr. Torres had been arrested, as had Miss Boone. But for me, what's really going to be significant in this conversation is, was she actually preventing any type of harm to herself at that moment in time? Was her life in jeopardy at that moment in time? And at this moment in time, I have to say no, I don't believe it was.
Absolutely. Carol Grayston, thank you so much. Carol has just gifted 5 Police Off the Cuff memberships to some lucky fans out there that can become part of the Police Off the Cuff family. I want to play this from Court TV. We'll get a good idea of where this case is.
Jorge Torres were spending an evening together at Sarah's home. The two were drinking, and what happened that night is almost inexplicable. George got inside of a suitcase that was then zipped shut. At one point, he wanted to get out and pleaded with Sarah to open the suitcase, but she refused. Instead, she turned on the video camera on her phone and started to record as George begged for his life. Still, she refused to unzip the suitcase. George died, and now Sarah has been charged with second-degree murder. Once she was charged, Boone was locked up in jail waiting for her trial date. But each time the trial was scheduled, it got rescheduled again and again and again. The main problem, Sarah's difficulty with her representation. 8 different attorneys have tried to represent her, and all 8 have dropped out of the case. The judge said 8 is enough, and he was going forward with the trial, so she would have to represent herself. And then Sarah Boone filed this want ad looking for a lawyer. Would anyone answer that ad? Would anyone step forward to save Sarah from representing herself? Tonight, we speak live with the man who answered the call, the man who will, believe it or not, represent Sarah Boone.
So, here we are, the old expression, Mike, and you've heard this a million times. A defendant who represents him or herself has an idiot for a client. I mean, that's a cliche expression in the law, and I'm sure all you lawyers
Oh yeah.
say that all the time. And in the lawyer rooms, you guys make jokes about it, but it's pretty damn true, right?
Yeah, the idea that she could actually adequately defend herself in a court of law is silly. They got this new guy named James Owens, I believe his name is, and he probably he's I'm sure a few favors were asked to get him to actually represent her, because why else would other people have dropped out? But if she does actually want to represent herself, it would be smart for the judge to have a trained attorney and admitted to the bar sitting at the defense table. And if she really wants to, she could do all of the motions. She could do all of the cross examinations, the direct examinations. She could do all that and consult with him and just have him sitting there. This way, it would avoid any sort of appealable issue later on if she's convicted and she wants to overturn her conviction by saying she wasn't well represented. The judge could say, look, you had your chance, you had an attorney right there, and you decided maybe to speak for yourself rather than have the attorney to do it. That's on you. So I think that would be the best way to do it. If she really wants to do it, let her speak, but have an attorney sit there, and this gentleman might be the one to just sit there. She may be a hard-headed person to go along with. She may not want to take her attorney's advice. She may think she knows the law better, but as you say, you represent yourself. You have a fool for a client.
Absolutely. I think in a perverse way, she's sort of enjoying this. She has herself in the spotlight. This is going on for 4 years now. What client do you remember in recent history or any history has gone through 8 attorneys? And by doing so, has prolonged their stay in jail because they're not convicted yet. And of course, if she gets sentenced to life, this won't even matter. But if she gets a certain determinate sentence of, say, 25 or 15, these 4 years count toward that she's been in jail. But she really seems, Dr. Debbie, to be enjoying the spotlight. Any thoughts?
Absolutely. I agree with you, Sergeant Bill. And we call this hedonistic killers. Remember, hedonism is pleasure, and many killers, such as I would say Miss Boone, including her in the category, derive pleasure from beginning, middle to the end of the process of the criminal justice system. And so I think in part this whole notice, let's call it, or advertising that she's doing for an attorney, she must have spent a great deal of time putting together that one-page ad, thinking that she was very clever and that she would attract somebody who may enjoy the spotlight with her, because she put words to that effect, that this individual who would represent her would, make a name for himself or herself and be in the media. And so apparently this is bringing her pleasure. I would agree.
I want to play this. This is really, to me, the most chilling part of this case. To see the voice coming out of the suitcase, it's pretty disturbing.
Suitcase. You'll hear Sarah Boone's voice. She's the one holding the camera. Let's watch.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
She's somewhat saying like this is payback
Mhm.
for everything. You could hear the words. She's slurring her words as if she's quite intoxicated. But I can't even imagine being inside that suitcase. How terrifying! And then realizing that your air supply is very much limited, right? And if someone doesn't get you out of there, you're gonna suffocate. You're gonna die of asphyxia. And he's sort of begging her to open. She drunkenly is saying, "Go," almost like this is payback for you.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it out.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. Sarah. Sarah.
For those listening, he's in a blue suitcase on the floor, calling out to his girlfriend to get him out of it.
Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
That's on you.
Sarah.
Real or ransom. I want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you chewing on me.
Sarah.
You.
Breathe, Sarah.
Yeah. You should probably shut the up.
Sarah.
That's pretty damn terrifying. And from a prosecutorial perspective, I mean, it's damning evidence against her. I mean, here he is telling her he can't breathe. Get me out of here. And she's like almost taunting him. Hey, that's how I feel when you choke me. Or that's how I feel when you cheat on me. I mean, Dr. Debbie, this is pretty powerful evidence. And watching it as human beings, you really sympathize with this poor guy who's inside that suitcase.
Yes, this is horrifying and chilling, and I think this provides the prosecution with a great deal of significant evidence. And I would classify this, Sergeant Bill, Professor Mike, and the viewers as the theory that I came up with called JAR, J-A-R, jealousy, anger, revenge. I think all three elements exist now, meaning she's referencing cheating. So that means she was jealous of any real or imagined infidelity. I think the anger is extremely obvious, even though she appears intoxicated, but the manner in which she's speaking, I think there's a lot of anger and intention. And ultimately, she is seeking revenge here for the alleged assaults perhaps of domestic violence and or this infidelity. So I don't see how potentially this could be based on what she said 4 years ago, that they were playing this game of hide and seek and she fell asleep and she wakes up and he's deceased. I don't believe that. And now she's alleging that it's battered women syndrome and that she wanted to protect herself. And I'm not sure I believe that. I just think this is an absolute horrendous and horrifying manner in which she chose to kill her boyfriend. And she was jealous, angry, and sought revenge in doing so.
Horrible. Mike, from a defense perspective, how do you overcome a video like that? Or do you?
I think what, when you see something like this, if I'm her defense attorney, I'm like, look, if you can, let's see if we can get a plea bargain offer to manslaughter, to say that maybe it was an accident and you never intended to do this. You're both drunk. You were laughing, and you were slurring. So obviously you thought this was all a joke, and you just thought he was kidding around. Whatever you want to say, this is horrible for a defense attorney to deal with, because when you look at this, if you don't get any sort of plea bargain offer, you could see what the prosecution's going to do. If I'm the prosecutor, I'm going to play this as many times as I possibly can to show how vindictive, anger and revenge, as Dr. Debbie said, she's right on, because this is what it shows. You just hear it in her voice. She's giggling. She finds it funny that he's begging her and telling her, I can't breathe. He's not laughing. He's not having fun. He's actually begging her. I don't think in too many states you could use a battered spouse syndrome like from domestic violence in this sort of case. That usually pertains to people defending themselves in the heat of being assaulted. Then I think people could understand, okay, you've been battered, so you're getting hit again. You just can't take it any longer. I don't think anyone's gonna, as a defense attorney, I don't think any jury's gonna buy the fact that, oh yes, in the past, they actually have had domestic violence incidents. They've both been arrested. And she said in the past, he's choked her and called her awful names and assaulted her and punched her. We can believe that. But does that syndrome, or does that affect you in many other ways, to the fact that you actually think he right now in that suitcase is a threat to you? And that's not going to work, because on police tapes, when the police first arrive at the house, she's telling everybody, oh, we were just drinking and having fun. It was one of the nicest days we actually ever spent together. This is a nightmare tape. And if I'm a defense attorney, I'm gonna get out the little flag of surrender 2 seconds after she won't go for a plea bargain arrangement, or the district attorney will say, no, we don't want a plea bargain with you guys. We want to take this to trial. I'm going to sit there and go, I don't know. I don't think we can go too far with this. This is a nightmare for a defense attorney.
Mike, it's not only that, but she's sounds very sadistic, almost like she's enjoying his suffering and bringing up past things that he's done to her.
It's payback.
This is like payback, and then like at some point she goes to bed, and she's drunk, so she sleeps about 12 hours. And wakes up the next day. What do you think happened to him? Of course, he's dead. Let me go back to law and crime here.
Uncover, and in this case, coming up next, how did the suitcase flip over?
Sarah. You. Sarah.
Stupid.
Sarah.
That's my name. The word up.
Sarah.
Sarah Boone is charged with second-degree murder after her boyfriend suffocated inside of a suitcase.
He's in the suitcase still.
There are multiple domestic violence incidents.
You two hitting each other.
Sarah.
That's my name. The word up.
He told you, Sarah, I can't breathe.
Jorge Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Trial. Live coverage starting October 7th on Court TV.
Again, pleading for his life. Let's take a look at the first video next to the second video. And the one thing that's clear to me is that it's not in the same position. It's moved. It's on its back on one, and then it's on the other side in the other picture. So it's not stationary. It's not like he's in the suitcase, he's locked in, and the suitcase stays there. Something else is at play here. Brings me to my next question, which is, how did the suitcase flip over? What's going on there? Is it him? Is she torturing him? What exactly is going on here that changes the position of that suitcase?
You know, there's also a thought that the suitcase may have tumbled down the stairs. So perhaps she pushed it down the stairs. In the autopsy, he did have some blunt trauma, which probably was caused him taking a tumble within the suitcase, either downstairs or something. And we see the suitcase in a different position. I mean, this guy obviously suffered on the way to dying of asphyxia. And it's just got to be absolutely terrifying, Mike.
Yeah, I'm thinking as I'm watching this, I was looking at those videos earlier today and reading about the case. I think it's possible that he died in the suitcase in the original position where we saw it when she's talking to him. I'm thinking perhaps that she turned the suitcase over maybe in the morning when her ex-husband got to the apartment. She called her ex-husband before she called the police. So he came over and maybe the two of them tried to flip it over so they could open it up. That's the only thing I can think of, because I don't think she would, in the middle of being drunk and having him asking for help, turn it over by herself. I think she and the boyfriend did it the next day. It is really disturbing, no matter what. Even if she did it by herself, that is a really disturbing thing to see, and to think that someone would actually do that to another human being.
Absolutely horrific. Folks, this is Police Off the Cuff Real Crime Stories. If you like real crime, true crime from a police perspective, then just hit that subscribe button. It's right on the screen. I made it easy for you. If you want to contribute to us financially, we have a Patreon with 4 different levels, and we have a YouTube channel membership with 5 different levels, in which Carol just gave away 5 new memberships to 5 lucky new Police Off the Cuff fans. Anyway, so this case is just, it's very disturbing. And then the fact that now the defendant is just enjoying the limelight. And I find that a little disturbing too, because undoubtedly she's getting a legal aid attorney. So guess who's paying for this? The taxpayers are paying for her defense. And she's digging on it, that it's all about her. And she doesn't care that she's staying in jail for 4 years awaiting trial, because this is the most fame she's gotten in her miserable life. Dr. Debbie.
Right. And so, similar to other cases we've discussed, I believe that some of these individuals who are accused of murder, whether it's the school shooters, and we've recently covered those, and whether it's an Alex Murdaugh or a Lori Vallow Daybell or Brian Koberger, I think some of these individuals, Sergeant Bill, Professor Mike, and the viewers truly are enjoying this type of macabre infamy. And so in so doing, they are taking the rest of us along in this process to view such evil conduct that I believe when it comes to court, the demeanor, the decorum will be discussed, and I think it might be used against them as well by the prosecution. You know, I have to wonder out loud here, is some of this orchestrated to where she might also want to introduce a mental health defect, and the fact that the giggling and the laughter and seemingly enjoying all of this is an attorney, or she herself in representing herself, going to say that she's mentally ill and she's incompetent and should go more to a mental health facility rather than prison. So how much of this is really her as who she is versus how much is maybe being orchestrated and manipulating some of the behavior so that it could help her in the future?
Yeah, I think that's you need to get a mental health sort of ruling to excuse you from things, and not just maybe when at the penalty phase, instead of you going to a prison, they'd send you to a mental hospital. I think you got to be pretty much off the wall. And she is somewhat, but she may not, she understands what she did. And I think that's where it is, right, Mike? If you understand right or wrong, you're not going to get an insanity plea.
No, you're right. It's a very low bar because you just look at a person. They're not running around howling at the moon. She can hold a job. She can drive a car. She dresses appropriately for the weather. She can operate a cell phone. So that's a really low bar to be considered sane. But I think what Dr. Debbie's really hit on a good point. As you were saying it, Doctor, I was thinking about what you were saying, and I'm like, you know what? This is going to be a jury with some men and women on it. If she could convince just one or two of the 12 people, if they're ladies or they're guys, but maybe a lady might see a little bit more, reliability in what she's saying. If they could see her acting a little bit irrationally, and maybe perhaps saying, you know what, yeah, she has some mental health issues. Maybe they're undiagnosed, but they're there, and maybe they're brought out by a stressful situation. And maybe somehow she believed that, as a battered woman, that she needed to set the record straight for him and to get him away from her, to show him how dangerous it is to attack her, that he could suffer too. In a weird way, I'm just trying to think, could she be looking at that to say, I'm playing a game to try to get one or two prospective female or maybe even male jurors to kind of sympathize with me in a weird way, even though he wasn't actually attacking me at the time, that I'm suffering from flashbacks or PTSD or something like that.
From the chat, Tish Pomfret's, so many directly negative consequences of a boozy lifestyle. Sarah's pent-up anger unleashed. She played with power while drunk, tortured, and humiliated him, ultimately depriving him of breath and depriving him of life, really, is what she deprived him of. The scoop, I haven't heard anything of drugs being involved, but they were both sauced up. They certainly were. Let's see. Vicky Floyd, I just don't understand this case. When didn't she record all of this and laugh about it? Why isn't she in prison for life? She killed this man. Vicky, she hasn't yet been tried because what we spoke about. Every attorney that she's had, she's fired or had some kind of issue with the attorney. Now, apparently, she has an attorney, but she's a very difficult client. So that, she apparently asked the attorneys to do things that is not sound from a legal perspective. So they say, no, I can't do that. I won't do that. I'm licensed to practice law. And if I do what you want me to do, I will lose my license. So she said 8 of these attorneys. And now apparently she has one, but it's a very slippery slope. The next attorney, will have probably an easier time of getting out of it than the previous 8 because she's gone through 8 already, so I don't think the judge is going to put up with much more nonsense from this lady as this case goes to trial. Let me go back to court TV. We'll play a little bit of this.
Well, I combed through the documents, and she is very clear that she had been upstairs. The suitcase was downstairs, and they got in the suitcase downstairs. So she says the suitcase was always downstairs. There were some items in there that they wanted to unpack. They took them out. He got in, and then she zipped it up. The only mention of the movement, which is clear in the videos, is by the detectives themselves in the police report, noting on the video that in the first, the suitcase is facing downward, and you can see George is pressing from inside to get out, whereas the second one, it's facing upwards and is moved over to the left side of the living room. It doesn't offer any speculation as to how that happened. And as far as I know, Sarah Boone's never given any explanation.
Let me ask you, Dr. Priya Banerjee, I guess 2 scenarios. I want to talk about one scenario, though. If she is moving this suitcase around and rolling it around, would you expect to find any particular types of injuries during the autopsy that could perhaps be consistent with someone being locked in a suitcase and sort of tossed around in that suitcase?
Yeah, I don't know the exact model of the suitcase, but obviously that would be available to my colleagues. Oftentimes, I think you would look for marks, like whether it be contusion, so bruising from any sort of ribbing, handle, the wheels jutting in, any kind of hardware or outpouchings. Usually, I mean, it's pretty smooth, but you don't know how he's like, scrunched up in there. The one thing I want to point out, though, is if, and this is pure speculation, if it was twisted while he was alive, you can see that the zipper is now on the bottom, right? If we're moving from position one being on the right-hand side of my screen to the side, where it's flipped over on the rug now, the sort of lid, if you will, the zippered portion is now on the floor. That's impossible to extricate yourself from. Even if he's trying to undo the zipper, which is faulty in and of itself, you can see, how is he going to lift the lid off? Even if he's trying to kick, I don't think it's so small. A grown man, even if he's petite, is going to have a very difficult time getting out.
Now, there's a video posted on Deep Dive True Crime on YouTube, which appears to feature audio from a police interview with Sarah Boone's neighbor. Now, in it, he describes hearing a loud crash. Let's take a listen.
Do you recall hearing anything coming from apartment 3 while you were, after you had gotten home?
Around 10:30 or 11 o'clock, there was a very loud crashing sound where I believe, I'm not sure, I haven't been in there hard on my roommate, but I believe it's the location of the staircase.
Okay, so
a little bit above.
A very loud, you said crashing sound?
Yeah, like it sounded like something that had been like falling down the stairs. Because it started up high and then it ended low.
Okay, Dr. Priya Banerjee, if this suitcase with a man inside shut is rolled down a staircase, what type of injuries would you expect? And would you expect someone to still be conscious and be able to talk the way George was when he was begging for his life?
Sure. Just to clarify, are you asking whether he's already inside the suitcase as he goes down the stairs?
Oh, yeah, inside the suitcase being rolled down the stairs.
Yeah, well, that's a whole nother can of worms. You can imagine as that tumbling motion is in there, he could bang around, and at least, I know it's a soft-sided suitcase, but there has to be some reinforcement frame in there. Those can add, bumps and bruises to him. So you should see some unexplained injuries in that source. I don't think there's any significant head trauma. From what I read about his cause of death, it was all related to the suffocation.
Dr. Priya Banerjee, Lauren Silver,
So, this is almost so hard to believe that someone could do this. But as we know, human beings do messed up things. And this brings me back my last year on the job. We had a case not just like this, except for the suitcase. A young woman was put in a suitcase and just left on the street. And it was right down the block from Rayo's on 115th Street and Pleasant Avenue, the famous restaurant Rayo's. And I was there when crime scene opened up the suitcase, and it was a young woman folded up. Her body was actually folded up to fit in, like her head was one way and her legs were folded. I mean, it was almost didn't look real when you saw a body that looked like that. And what it was she was smoking crack with this guy, and he sent her out with his debit card to get money and to get more crack. And of course, we know what someone that smokes crack is going to do. They're going to help themselves to more money on his account and buy the crack, but also steal lots of money. And that's what she did. Because of that, he killed her. And one of the ways the case was solved was a detective, and I'll mention his name, Tony Rivera. He canvassed a lot of the stores on 2nd Avenue and found the store that they bought the suitcase from, which was pretty damn amazing detective work. And then with the finding the store, he found the video of the person that bought it. And then the case started to unfold. And then, we talk about all the time, there's video everywhere. And the killer wheeled the suitcase and just left it there. And so we had video of the killer along with the rest of the evidence. Anyway, I just thought I would mention that because it's a bizarre thing to see a human being dead inside a suitcase. And other than, asphyxia or whatever, she looked perfectly alive. She hadn't even been dead very long, and it was freezing outside. So her body was like preserved. But anyway, that's another story. But this story is so bizarre. And then, of course, now getting to the court part of this, we're getting closer and closer, Mike, to potentially a trial. And again, she wanted to represent herself, and the judge doesn't want it. And apparently there's an attorney right now, but he's probably on a very, very thin line. Like he'll quit in a minute if she gives him any crap. What do you think?
Yeah, he's the name is Owens, James Owens. He's behind the 8 ball at this point because the judge is adamant about starting in October. He wants a 2-week trial starting, I think, October 7th, and there's very little time left. And the Mr. Owens has filed 2 motions, one pretrial motions, and they need to be granted quick before the trial starts. And the judge isn't too happy about it. The first one is he wants Ms. Boone to have her hair done, and so that she looks much more presentable in court when she shows up for her trial each day. So she doesn't look haggard, doesn't have that prison pallor, that you get going on, that she looks much better than she would look if she just got like secondhand clothing from the attorney's office. That's one. The second one, which is more important, is that he wants to have her conversation that she had, not the initial 911 conversation that she had with the initial response to the first police officer who appeared on the scene, but her official interrogation by detectives in headquarters. They want her all of her statements thrown out because the attorney claims that the detective who was interrogating her, when he read Miranda, he left out the last sentence, which is, "Now that I've read you your rights, are you willing to talk to us?" So he claims that mistake throws out and invalidates all of the statements that she made, saying, "Oh yeah, it was a good day. We were drinking. We were looking at artwork." Never, ever, ever mentions any sort of domestic violence whatsoever. So now that they've gone to this domestic violence abused spouse syndrome, they want that thrown out. They do not want the jury to hear that, oh my goodness, we just had a great day. We were drinking wine and it was a big old accident. They want that thrown out. So the judge is really kind of getting testy with the attorney, but this is all coming to a head. And in the next couple of days, probably in the next 4 or 5 days, he'll make his rulings, and then that's it. They're going to have the trial. But we're getting to the very end. Finally, after 4 years, there's actually going to be a trial.
Amazing. Let me show you who this attorney is, and we'll just listen to a bit of his presentation.
Judge, as you know, I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did. That constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it. The greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Moving now to, give me a moment, and I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thanks, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the 2 detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow.
You know, Mike, this is something that, is very serious. I mean, it seems ridiculous in a way, like they read Miranda, and at the very bottom, now that I've read you your rights, are you willing to answer questions? That's basically the line that they left out.
Right.
I don't know if a judge will suppress the statement based on if in fact the detective did leave out that he may, because also if this is a death penalty case, if he leaves that in and she's found guilty, it leaves him wide open for an appeal. And judges don't like to be reversed on appeal. So he may rule, let's throw out the whole interrogation. And folks, we're always sort of desensitized or Hollywoodized or TVized to Miranda, because every time Law and Order locks someone up, they're like, John Smith, you have the right to read. The guy could be across a busy street in New York City, and the guy hears him reading Miranda from across the street. It's so ridiculous. That's never, ever how it is done. That is not how you read Miranda to someone under arrest. And when you do it, usually it's done inside the interrogation room. And, well, then you may say, well, what if cops ask them questions on the way to the station house in the car? We don't. You're trained not to, or good investigators, detectives, we don't. I took a double murderer from the Bronx into Manhattan, and it was total silence in the car. And all experienced detectives, we knew not to ask them anything, because that's the first thing a defense attorney said. What did you talk about on the way back from the Bronx? Nothing. Oh, you didn't? We said nothing. And then what's the defense attorney supposed to do, right? So then you sit down with the defendant in the interrogation room, and it's read from a pre-printed sheet. And each right, the defendant initials it next to the detective's initials. So there are no mistakes. And that's submitted with the case folder, and it becomes part of discovery, and the defense attorney gets a copy of it. So there is no doubt, there's no questions that Miranda was read and it was read properly. This is sloppy police work if she, in fact, forgot to read that last line. Mike.
Yeah, Billy, you should always read it. I remember I used to read it. I mean, I could recite it in my sleep, but I always used to actually read it to the perp as I brought him in front of the desk sergeant. And people would do that when I was a desk sergeant. I would make them read it word for word. And if they needed an interpreter, they'd get one. So the defendant would get it in his own language. If the officer was sloppy, that's not good. However, it doesn't have to be perfect. If all the detective did was say you have the right to remain silent, anything you say can will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be pointed to you for free. Do you understand these rights? If she just stopped right there, to me, that's the sum and substance. That's the real intent, and that's the real important part of Miranda. If she left out the last part, I think she should be, warned about that. But I don't think a judge, this judge especially, this case has been going on for 4 years. I think he wants us to go to trial, and I think what, he probably will follow Florida law, and I'm sure this kind of issue has come up before, at least once or twice in the past decade or two, and he'll look at what other judges have decided and just go right along with whatever they decided. If they decided it's got to be perfect, then he's going to throw it out. If they said, well, if there's a mistake about how you say something or you miss a word or something like that, then it's okay. Then it'll come in. So I think he'll just go along with what everybody else would do. I don't think he's going to break new ground or anything. But for me, all I want to see as a judge, I want to see the first two parts about the incrimination and the attorney read. And if, because that's 99.9999% of what Miranda is really all about. But you're right. It shouldn't have been done that way. It should have been read verbatim from the card.
Dr. Debbie, your thoughts?
Yes. Well, I don't know if I ever mentioned to both of you and the viewers, but part of my teaching career, I was very delighted to have the honor of teaching police recruits report writing. And I did that for many years. I even wrote a book on report writing, reported in writing. And so what happens here in Florida is that the officer is to even put in his or her report, I read the Miranda warnings to the suspect per my card. Now, I appreciate both the points that you're raising. With Sergeant Bill, is it possible that because the procedure, policy, protocol wasn't followed, let's say, letter to the law, and every word was not spoken, and we know judges do not like to open the door or window to appeal, then that's a possibility. And then, of course, Professor Mike, what I'm hearing you say is overall, the officer's intention, we could say, operating under good faith and overall got to the meat and potatoes of what the Miranda is supposed to do. So it can really go either way, and we'll have to see what the judge will decide on this one. But it's an issue, I think.
Absolutely.
Yeah.
I'm going to go Banfield. I want to quick listen to Ashley Banfield for a few minutes talking on this topic. Come on, Ashley. Come on the screen. It's just loading up. This one is, I may have to remove it if she doesn't start talking soon. But they're talking about how she's going through to lawyer number 10 in this case, which is really outrageous when you think about it. It doesn't seem like it's loading up, so I'm gonna take it off the screen. The point is that she's going for lawyer number 10, and how much of a patience does the system have with someone like this? It goes through 8 attorneys, and now the judge is talking about a hairdresser and a makeup artist. Like, I mean, after a while, the public's got to be like, what the hell is going on? This woman killed her husband or killed her boyfriend, wouldn't let him out of a suitcase, yet they're providing a hairdresser and 10 attorneys and, basically bending over backwards to see that she gets a fair trial. And when does the system say enough is enough? We've had it. Let's get this trial going, which apparently is what this judge is doing, Mike.
Yeah, Billy. Yeah, he's lost a lot of patience. It's been 4 years. Now, remember, you're guaranteed the right to a speedy and public trial before a jury of your peers, okay? And so, therefore, if she is truly innocent, totally innocent, that truly innocent defendant wants the trial done as fast as possible so they could be exonerated and get back out into society. Anybody who stalls constantly, to me, that seems like that you're in trouble. You know what you did is wrong. We can argue about whether it's manslaughter or murder, but still, your actions directly took a human life. So therefore, you should stall as much as you possibly can before you get that trial. So I don't think that stalling makes it look good in the public eye when they look at her to say, is she really innocent of a crime or not? But the stall tactics aren't good for society. We want swift and certain justice, whether that person is exonerated, an innocent person exonerated, or a guilty person is punished. And so therefore, this isn't doing her any good. It's probably, if you think about it, because we are all humans, and even judges, occasionally they lose their patience, and she may actually lose motions that she might have won a year or two ago. But because now it's going on 4 years, and this 9th judge, Mr. Owens, is sitting there trying to play catch up at the last second, filing motions, he may actually lose motions that may have merit only because the judge is like, I've had it, we're going to trial, that's it. So it's really, if she's thinking that all these delay tactics are doing her any good, I don't think so. I don't think so at all.
Mike, think of how many motions, though, the prior 8 or 9 attorneys have filed. The case folder must look like, 10 Bibles,
right.
To get, the amount of paper in it. And it doesn't necessarily mean that she's going to get a better trial just because she went through 8 or 9 attorneys. It's sort of crazy. Kilo Charlie Tango. Judge Kranick can't possibly agree to hair makeup. It would open up a can of worms going forward. Street clothes and modified restraint, sure, but not a glamour shot session. Kilo Charlie Tango, I think because he was going to allow her to represent herself. So then, of course, he wanted her to be able to appear in business attire so that a jury would, take her more seriously than someone that's wearing like an orange or a gray jumpsuit, even better with those old zebra outfits,
right,
that you used to see in the Little Rascals and stuff. But so, yeah, maybe that's the only look. Judges absolutely bend over backwards to give a fair trial. Dr. Debbie, your thoughts on that?
Yes, I think we're moving away from the stall tactics, and I think it's now time for the spotlight tactics. And so what's in the spotlight is Miss Boone, her behaviors, her actions, her statements that are on this video, and what she has done. She has killed Mr. Torres. Now, what do we have to prove it? We have her talking to him. It's horrifying that he's still alive, begging for his life, but the manner in which he's speaking, I think he's trying to stay as calm as possible by constantly using her name, Sarah, Sarah. He even affectionately refers to her as babe. But her replies and her responses are just so horrendous that I don't think we can deviate from what her intention was. And the issue of the suitcase, that is important. I think we have to consider what the neighbor is saying. I don't think somebody makes that up when they hear this loud crash or boom, what sounded like he described coming from the top of a stairwell. And that, for me, just adds another extra spotlight on detailing her intention here, not only to kill him, but possibly overkill, even hurting him while in the suitcase. So yes, we've seen the stall tactics for 4 years. And I think as we draw closer to October 7th, I think a lot of these pertinent issues will be in the spotlight.
Absolutely. Let me just play a little bit more of this from the law and crime trial.
A bottle of wine last night. Okay. So then it's like, we decided to play hide and seek, right? Okay. So he gets in the suitcase. Okay. Who is this guy? That's my ex-husband, my former husband. How did he live here with you guys? No. I called him over here. Okay. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Here, let's talk in private, okay? I called you guys. I tried giving your brother. The problem is I fell asleep. I fell asleep. When did you do CPR? This morning, when I found it. Before you called? Yes. 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, "Oh, he's in the suitcase still." And that's when I found him, and I took him out. I tried doing CPR, and then I called him, and then I called you guys.
Did he get here before the fire department got here?
Who?
Your husband or your ex-husband?
Yes.
Okay. Where does he live at?
Right down the street.
Okay. So you were playing and you did some up in.
I did, but then I fell asleep.
Okay. You're okay. I wasn't here. I'm just trying to figure out what happened.
I fell asleep, so I don't know if he suffocated or if I had an aneurysm or a heart attack or what.
What kind of medical conditions did you have?
None that I know of.
Nothing that you know of.
None
You
that I
didn't take
know
any
of.
medical?
No. All we had was a bottle of wine. Literally, just a bottle of wine.
Okay.
Doing puzzle artwork. Then we decided to play hide and seek. That's all that happened.
So
that's pretty amazing there. So if they did not find the video of her videoing and taunting him, she gave a pretty good performance there. I don't know what happened, but they have that video that shows her taunting him, shows him begging for her to let him out of the suitcase, and then she goes to sleep for 12 hours. Your thoughts, Mike?
Oh, okay. Yeah. It's sad because, in a drunken stupor, she probably wanted to, give him a little payback for maybe past abuse, that sort of thing. And so, if she had only, opened up that suitcase and if she did, who knows, maybe they would have started fighting again. Who knows if they would have hugged and made up, like that. But she fell asleep. And so she was at the very least, at the very minimum, that's recklessness. That's manslaughter. Well, as we're talking to this and we've gone over it and I'm talking to you and Dr. Debbie, I'm thinking of perhaps, you could get to murder because that's higher level of homicide, because of the suitcase going down the stairs. That shows a real, kind of like viciousness, where that's not reckless, that's intentional. You are beating this person in addition to letting them sit there in their own suitcase and die. This is really bad, and the more I think about it, the more sympathy I lose. If I have any sympathy left, the more sympathy I have, I lose for her, to the point where this is kind of cold-blooded.
Yeah, well, that's why I think they're really hanging their hat on depraved mind murder more so than just intentionally. Dr. Debbie, your final thoughts.
Yes, I agree with Professor Mike, just to piggyback on something he said. And I think if we did not have this video, of her using curse words, profanity, the issues of, well, this is how it feels when you've cheated on me, and this is how it feels when you're strangling me. Let's just say we didn't have that. Then I might potentially think that this could be a crime of manslaughter, where yes, her recklessness of potentially being drunk, him being in this suitcase, she falls asleep and wakes up. For me, it would be a maybe. However, with all that we're talking about and what we have as evidence, I feel, even though I will always maintain the innocent until proven guilty, with the asterisk by it, of course, there's a lot here that is just suggesting what she did, and I think a lot of it stems from that jealousy, anger, revenge, and this conversation while he's in the suitcase, Mr. Torres, and Miss Boone is just literally, I think, wanting complete and utter power, control, and authority over him, and she enjoyed it.
Yeah, I agree. Mike, your final thoughts?
Billy, I think I agree. I was looking at some of the chat, and there's a girl, lady named Veronica, and she said, this is crazy. No way should he take this to trial. He should plea bargain. Veronica, if you're still listening, I agree with you 100%. If I'm her attorney, I'm begging for a plea bargain at this point. I do not want to go to trial. The jury is going to sit there and look at that video, and you just watch it. That's a haunting video that will hurt any possible mitigating circumstances that you can come up with about maybe being hurt in the past, cheated on, slapped around, choked. People are going to look at that, and you're hearing the dying gasps of a dying man. So, Veronica, I agree 100%. She should go for a plea bargain. I don't see anything good coming out of this trial for her.
You know, Mike, I think you're right that she should, but the state may not be offering it.
Yeah, they might not be offering anything.
The state may say, hey, she's messed with us for 4 years, 8 attorneys, 9 attorneys. No, we're taking her to trial. We're not offering her shit. The offer is murder too, depraved mind.
Right.
Right?
That's a life sentence, right? That's
right,
a life
exactly.
sentence.
So that's the offer. There is no offer. There is no manslaughter. You want to play games? We're going to play games with you. And believe me, prosecutions do that. And they get vindictive. And, well, look, when you watch that video, any human being, it's infuriating. It's totally, she could have easily have saved his life. Just unzipped the damn suitcase, you know. Instead, she was in a drunken stupor, and she drunkenly goes to sleep. And the guy, think of what a horrible death that was, you know. 10, 12 hours in a suitcase. You die slowly of asphyxia. It's just unthinkable. Anyway, folks, thank you so much for tuning in tonight. This was a relatively a new case for us, taking a look at this case. It's interesting, but yet it's somewhat predictable when you see, and you would hope that if she does take this to trial, she gets what's coming to her. So, folks, thank you so much for tuning in. I'm Bill Cannon from Police Off the Cuff Real Crime Stories. On behalf of myself, Professor Michael Geary from, what is that, Albertus Magnus, and Dr. Debbie Goodman from St. Thomas University in sunny Miami. Thank you guys so much for being on the show. We'll see you next time. Have a great night, everybody.
Thank you.
God bless.
One episode just ain't enough.